In Nigeria, children of a deceased person can actually apply for probate, even if they are not named as executors in the will. But be clear that what I mean is that this is under certain circumstances. I'm aware that I just said it's executors who can apply. But where there are no named executors, that is to say, if no named executor is available or willing to act, a child that is above 18 years can apply for probate as what is called in Latin administrator cum testamento annexo, which is simply in English an administrator with will annexed. The court will consider the child's application and may grant probate if it is in the best interest of the estate and its beneficiaries. I had just talked about possibility of objection, challenge to an application for probate. The question should be who can challenge this application for probate. The answer is that any person with legal interest in the estate may actually challenge the probate application. And this usually would include disinherited spouses, spouses who were not accommodated in the will, or children who were not accommodated in the will, or creditors, persons to whom the deceased was obligated, whom he was owing money or some other thing. Persons who are also claiming under a previous will. In other words, where the person deceased had made a will previously and then a new will is read and those ones realize that they are no longer accommodated. They may go to court to find out what went wrong. Such disgruntled or affected persons can object to the application for probate by issuing a caveat. When a caveat is filed, it halts the probate proceedings temporarily. Next, let me answer the question, who can challenge the validity of a will? This is different, note, different from who can challenge an application for probate. When you are challenging probate formalities, it's different from when you are challenging the existence of a will. The heirs at law or next of kin or spouses and children under the Marriage Act or customary law, or persons who would ordinarily inherit under intestacy laws can challenge the validity of a will. And these individuals must show legitimate interest or injury that would occur if the will is allowed to stand.